Welcome back to This Week in Immigration. I'm Jordan LaPier. On this week's program, DACA restarts, sort of, unpacking two storylines on immigrant families and children in government custody, and how the latest round of COVID relief may affect immigration policy and agencies. All that's just ahead. Stick around. Here with me today, as always, are Theresa Cardinal Brown, Director of Immigration and Cross-Border Policy. She's on Twitter at BPC_T Brown. Hey, Theresa.
Hi, Jordan.
And Cris Ramón, Senior Immigration Policy Analyst. He's on Twitter at CRamonBPC. Hi, Cris.
Hey, Jordan.
Thanks to you both for being here. Welcome back to the program. Let's start here this week. A new memo from the Trump administration released late last month offers something of a restart of the DACA program. The memo came alongside public pressure to start receiving new DACA applications after the Supreme Court allowed the program to continue when it ruled the administration didn't properly wind it down. But rather than taking that step, the administration is only allowing current DACA recipients to renew their status, and for only 1 year rather than the previous 2. The memo also left open the possibility that DHS may end the program in the future, leaving the long-standing state of limbo in place. Theresa, walk us through what this memo says and why the administration issued it when it did.
Sure. So the memorandum is from the acting DHS Secretary, Chad Wolf. And like all of the other DACA memos preceding it that purported to terminate the program, it's done by the Department of Homeland Security. In this memo, the acting secretary officially repeals both the Elaine Duke memo from September 2017 that first tried to end the program, and the Kirstjen Nielsen memo from early in 2018 that, following an initial court case, a court decision, tried to re-rationalize the ending of the program. So it repeals both of the memos that all of the DACA cases were based on. It is a new memo, and it basically says that DHS is going to take some time to figure out what to do with the DACA program. In the meantime, it will continue essentially the status quo. People who already have DACA can continue to apply for renewals. However, their renewals of their work authorization will only be valid for 1-year increments rather than 2 years. The memo also makes fairly clear that the acting secretary believes that the program should be ended, that it should not continue. The other interesting point in the memorandum is that it refers to the fact that Attorney General Barr has repealed a memorandum from previous Attorney General Jeff Sessions that gave the opinion of the Attorney General that the DACA program was indeed illegal when it was created. This is important because the Supreme Court decision actually said that, although they didn't say that DACA was illegal, they said that when an attorney general issued that memo, it became binding on DHS. So by repealing that memo, the attorney general is saying, well, we're not telling you it's illegal. DHS, it's up to you to decide what to do. What it does, as far as I can tell, is at the very least gives the Department of Homeland Security room to make no further changes to the program until after the election. But what it doesn't do, and what the Supreme Court ruling said it should do, was take the program back to how it was under the Obama administration. And it does not allow people who aged into qualification, which means they turned 16 after the Trump administration tried to end the program, to now apply for status. And that's a very big deal because tens of thousands of potential eligible DACA applicants are no longer able to apply for status and are left out of the program while it's still held in essentially a new limbo.
Cris, how do those limitations in the memo around who can apply for status now affect the program moving forward?
I mean, essentially what you see is the program's just going to be maintaining the status quo that we've had more or less for the last couple of years, but without the opportunity for giving individuals an opportunity to receive these benefits. So in a way, it's just simply a continuation of existing protections for individuals who already live here and who have already received and renewed their DACA status, but anybody, like Theresa said, who's aged in, who may not be able to actually be able to apply. I mean, that's a really significant, at least bluntly, a setback for a lot of these folks who had been relying or been banking on the Supreme Court decision to at least bring things back to the way that things were during the Obama administration, and that they would have had an opportunity to be able to apply for these benefits. But that hasn't happened. So in a way, it sort of created this like little bubble of individuals who are in this country who have these protections, who have these benefits, but everybody else who's outside of that won't be able to access that. And I think that really then puts a lot of pressure on Congress to be able to come up with some sort of legislation to be able to address this. One of the things that's always concerning when you have these kinds of immigration programs is that you're going to sort of create a program that'll provide protections for a certain number of immigrants. And unfortunately, what ends up happening is that bubble of individuals who receive those benefits only gets so large, but without broader changes that provide, at least for the undocumented, that provide a pathway to legal permanent residence, you're just going to keep perpetuating this problem. So in a way, there's the individuals who already have those protections. They'll hopefully be able to continue to get these protections and renew them. But I think that this is really going to put more onus on Congress, or should put more onus on Congress to act, just because the fact is the program now has a much more limited scope, and the underlying issues of providing a pathway to legal permanent residence for this population, for Dreamers more broadly, but even DACA recipients who could age in and who were applicable, I think now that puts the pressure on Congress, or should put the pressure on Congress to act.
Theresa, I'll come to you with this, but I want to have both of you weigh in on this question. You mentioned that this memo does not necessarily align with what the Supreme Court called on the administration to do to bring the program back to what it was under the Obama administration. Given that, do you expect to see more litigation stemming from this memo and more litigation around DACA?
Yes, absolutely. What I think is important to understand is that the Supreme Court basically upheld a lower court decision that said that the Trump administration had improperly terminated the program. It opened the door to the administration terminating the program by following some specific rules. But in the meantime, that lower court decision would have rolled back the program to how it was at the end of the Obama administration, including allowing new applicants to enroll. By not doing that, the Trump administration and Acting Secretary Wolf opened themselves to litigation over that particular issue. But there's another angle at play here. The prior memos from DHS Secretary or Acting Secretary were by people who were undisputably either Senate confirmed or acting in their roles. Elaine Duke was the Senate confirmed Deputy Secretary. She was acting secretary after John Kelly departed the position, and no one disputed that she was eligible to be acting secretary at the time. Kirstjen Nielsen was a Senate-confirmed Secretary of Homeland Security. Chad Wolf is Senate-confirmed as Undersecretary for Policy and Plans at the department. There is no Senate-confirmed secretary. There is no Senate-confirmed deputy secretary. And there are questions about the order of succession in the department. And so there are some who are challenging his authority to issue a memo at all. And I think that would be a key issue moving forward as to whether or not he is appropriately in his position and has the authority to issue this memo.
Cris, what's your read on all these issues? Do you also expect to see some litigation?
Possibly. I mean, I think, the question is, I think the litigation, one area to think about this obviously is how the program's going to be wound down, when it's wound down, and whether or not people are going to try to sort of look at that process and try to file litigation saying it was done improperly. I think that's going to be, the point where you might see a lot more litigation and trying to ensure that the program continues to exist. So there, and that's the pattern that we've seen with this period in immigration history, is that the Trump administration takes an action and then advocates subsequently sue it, and then of course things just sort of go from there and may eventually hit the Supreme Court, much like it did with the issue about the DACA rescission. So certainly I think that there will be ways of looking at how they contest a potential rescission of the program. This memo sort of, I think it's just standing there, and we'll see whether or not there's going to be additional pressure on that. But I think the real pressure is going to come in via litigation if DHS decides to eliminate this program. Of course, the obvious thing is that this may not be resolved by November when we have the presidential election. It may not be resolved if President Biden is coming in January 2021. This may not be resolved, but there might be an effort to at least try to address the legal status of those individuals. And if President Trump is reelected, the litigation is going to keep on going, and the administration is going to keep pushing on that. So more or less a status quo with what we've seen here. But I think, like I said, it's going to be the rescission that I think might be targeted.
I would just also point out probably a not unlikely scenario. Should President Trump lose the election, a memorandum rescinding the program in a lame duck might be one of the last actually tries to do on the way out. It would also be something that could be easily and quickly undone at the beginning of a Biden administration, but you would definitely have a period of uncertainty between the election and inauguration in that case.
Okay, when we come back, the latest on immigrant children and families in government custody. Last month, several media outlets reported on instances where ICE held children at Hampton Inn hotels in Arizona and Texas before their expulsion under a CDC order called Title 42. After those stories came out, Hampton Inn canceled their contracts with ICE and advocates filed suit. Now, this all comes after a June court decision requiring ICE to release children in its facilities for more than 20 days due to coronavirus concerns. Cris, I'll start with you. What's the context for these two stories?
So the context for these two stories is sort of where the Trump administration, what it's been doing with the border and what it's been doing with families and the intersections on that. The most recent story about, these children who are held in the Hampton Inn, the Trump administration this spring introduced a policy called what we're now calling a Title 42 program, because it was invoking a part of healthcare law that allows the U.S. government to return non-citizens who are arriving, to the United States, to return them due to issues around communicable diseases. And this program has now really been expanded and has become the primary way that the administration has been basically deterring individuals arriving at the U.S.-Mexico border and expelling them and removing them from the border. So these kids were individuals that would be expelled from the country under this order, which isn't an immigration process, it's actually a separate process. And so these kids, under most instances, what we've been hearing with Title 42, at least reporting from Nick Miroff at the Washington Post, is that individuals are usually returned to Mexico within 96 minutes. But obviously, that's just simply an average, and I'm assuming that's probably going to be mostly for the case for adults. But for children, this story kind of, highlights a couple of things, which is one is that, obviously kids may not be immediately be returned. They may be put in custody before they're expelled from the United States. So, the issues around this is that these kids are wrapped up into a new border program for removing immigrants who are arriving there. And so that's the reason why they were in those hotels. They weren't going to be removed immediately, but clearly they were going to be moved fairly quickly, and that's the issue for this one. The second issue about this, this issue around, thinking about binary choices, this decision. This is a policy that popped up in the spring, in May, I believe, and you saw advocates in particular highlighting this issue where parents basically either could say that their children could be released from immigration custody and they can, be released to a family member or to another location while they stay in immigration custody. And, and that would be one choice. Or the other choice is that they waive their rights for having their children be released from immigration custody, and they have to do that within 20 days. at least in DHS custody before the children are released to either HHS or to a family member. Basically, that is the decision they had to make. They either say, you know, kids are staying with me, they can't be released, or the kids can be released, but I stay here. And the advocates have been saying that this is a new version of family separation, which, if you recall, was a policy about 2 years ago, where parents were separated from the children due to the prosecution of parents for illegal border crossings. So that's a lot to say that basically some of these kids are wrapped up in policies that the administration set up at the border, and some of these are policies that are happening in detention here in the United States. But certainly it's been putting a lot of immigrant families and children certainly in pretty precarious situations.
Theresa, I want to come back to this June court decision that required ICE to release children who had been held in its facilities more than 20 days. Does that stem from the Flores settlement? What's the genesis of this ruling?
Yeah, it does. The attorneys for the Flores settlement took DHS back to court, saying that they were holding immigrant families in detention longer than 20 days. The judge in the case had previously told the government that even if kids were with their parents, the Flores settlement required them to be released after 20 days, either with their family members or to HHS. The government has decided, as Cris said, not to release the families, but basically forcing the parents and saying, we're not going to release you. So your choice is either to let your child go away and go into a separate system away from you, or waive that right and stay together in our custody. Advocates are furious at this reading. Unfortunately, the judge in the Flores case has said, yes, that's an appropriate reading of the order, that the department is not necessarily violating the order by giving parents that choice. The main thing is that either they have to waive the rights for their children or the children are released. That has led attorneys for some of the families to actually be mad at the lead attorney in the Flores settlement, that is an attorney from California named Peter Shea, arguing that he is not actually acting in the best interests of the children or the family. And they filed a motion to be able to represent their families separately. So this action by the government, the ongoing litigation around the Flores settlement, has created fault lines amongst the advocates themselves. And it's further, I think, evidence that the way we are treating families and children at the border is very controversial, especially in light of COVID. The policy of this administration that families shall not be released pretty much under any circumstances is forcing these very difficult decisions. And then I want to circle back to something on the Title 42 issue with the kids in the hotels, and something I've said before. DHS believes that this CDC order, the Title 42 order, essentially supersedes all immigration law at the border, including the law that specifies that unaccompanied children must be turned over to HHS custody within 72 hours. They say basically they're not in immigration custody. We're just holding them until we can remove them wherever. There's no immigration process, so they don't have to follow that rule. And that is one of the reasons why they were not holding them in detention. They were not holding them in their own facilities, but putting them up in these hotels. So for people who remember in the height of 2018, the family separation policy and all of the, coverage of that and the backlash that the public had toward that family separation policy, we have to remember that kids and families are still being faced with these terrible choices at the border today due to continuing policies that are being put in place.
So given all of this, Theresa, do you sense that these stories are going to lead ICE and HHS to make any changes in their practices around holding children in custody?
Well, they haven't so far. And I think part of it is, as I said, we haven't seen the same kind of national level attention and backlash to these cases. So far, most of the reporting has been localized to border regions or immigration reporters. It hasn't broken out into the mainstream like the family separation in 2018 did. That having been said, the government has continued to do these policies in spite of litigation. Unfortunately, the courts have said that this binary choice is allowable. They have not yet weighed in on the kids in the hotels, although that case is coming. And I think there is also litigation on the Title 42 order itself. So, but so far, this administration and Department of Homeland Security and the attorneys for the Justice Department basically continue to argue that it is in the interest of the United States to maintain custody of immigrants in the United States until they can be deported, and that releasing people into the country is just either under COVID dangerous or would incentivize additional legal or illegal immigration. That is their position. They are holding fast to that, and they continue to do everything they can to avoid having to release people in the country.
All right, after the break, how COVID relief in Congress could affect immigration policy and agencies. Finally today, Senate Republicans are out with their proposal for the next round of COVID relief called the HEALS Act. And this comes months after House Democrats passed their own bill called the HEROES Act. And while that bill contained an extensive list of immigration provisions, the Senate bill included just two: a $1.2 billion loan for U.S. Citizenship and Immigration Services and $1.6 billion for Customs and Border Protection. However, some Senate Republicans are seeking to include more expansive immigration provisions in a final bill. Cris, walk me through the big differences between the HEROES Act and the HEALS Act when it comes to immigration.
So basically, the difference between the two bills is that the HEROES Act has a lot more on immigration that I think reflects the priorities of House Democrats, while the HEALS Act is far more bare bones on immigration and doesn't really do a whole lot. And doesn't even necessarily reflect the priorities of Republicans in the Senate. In terms of the HEROES Act, you had, first and foremost, you had payments for mixed status families and for children, U.S. citizen children with parents who are ITIN filers. These two groups were actually left out of the CARES Act, and they didn't receive those payments. So that was the first thing that the HEROES Act did, a very expansive vision of this. But they are also, there's some provisions that really try to expand the workforce, particularly for COVID response efforts, either through temporary visas or permanent visas. That was something that was very expansive. There were also efforts to, provide, resources to be able to hold remote naturalization oath ceremonies, be able to provide for some Medicaid testing, and basically there were also some provisions also that basically mandated the release of COVID-19 vulnerable detained populations in immigration enforcement. So really expansive and does a whole lot that I think House Democrats have been wanting. But if you look at what the HEALS Act did, is just basically, some funding for CBP and a $1.2 billion loan to USCIS. And if we've talked about this on this podcast, USCIS is facing a funding shortfall that may lead to furloughs. So, the Senate then said, okay, we're just going to include this loan into HEALS in order to address that problem. So really like night and day in terms of just how expansive the HEROES Act is on immigration in comparison to the HEALS Act. There's very little difference between the two. There's a major area of difference between the two. Not a lot of similarities there.
So that having been said, though, there are some Senate Republicans who are looking to expand some of the immigration provisions in the HEALS Act. Walk me through some of what they're looking at doing.
So there's sort of two areas where they're trying to be active. One is actually on this issue around payments for mixed status families. What we've seen is that Senator Marco Rubio has been championing, standalone legislation that would at least provide some payments from the CARES Act to mixed status families. So if you were a U.S. citizen, you had a legal permanent resident spouse, or you had a spouse with an ITIN filer, that you can get some payments for that because you were excluded from the CARES Act. Senator Rubio has actually been pretty active on this, and you've been seeing some Senate, particularly moderate Senate Republicans, being pretty active in this area, which is a little bit unexpected, since you normally would see Democrats doing this. But here you're already having Republicans who are being a champion for that, and that's great. You're also seeing Senators Daines and Romney actually also promoting some legislation that would provide payments in future COVID-related legislation for these two family structures. So once again, you're a citizen, you have an LPR spouse, or your spouse has an ITIN. There's payments for that. So that's kind of the major bucket. Obviously these proposals aren't expansive as the CARES fixes that you saw in the HEROES Act on the House side, but it is trying to at least ameliorate some of the problems. And the other area is just that some Republicans have also been pushing to have, some legislation where you could have some unused green card visas be, from this year to be used for bringing in healthcare professionals to be able to help the United States deal with the COVID response. Now, these two buckets are things that have been standalone legislation, but there has been efforts to at least try to push this into whatever the Senate was going to do on COVID. There's a lot more pressure on payments for mixed status families, both the Rubio proposal and the Daines-Romney proposal, to put that in there. It's looking increasingly likely that at least there will be a very strong push to have the Rubio proposal be included in HEALS, but that's not completely guaranteed. We're unsure whether or not the push to be able to use these unused visas for healthcare professionals, whether that will end up. There hasn't been as much attention and focus on that to include that in HEALS. So, taking a look and a step back, potentially we could see the Rubio proposal be included in HEALS Act. That's the likely candidate, but we'll see what else happens on immigration. But these are the two major buckets of really where Senate Republicans are active on this issue.
Theresa, obviously the negotiations around another round of COVID relief turn on things other than immigration policy, but what's your read on the politics around those negotiations when it comes to immigration?
Well, I think what makes it challenging is that there are essentially three camps negotiating this bill. There is the Senate Republicans, there is Senate and House Democrats who are mostly aligned on most of these things, and then there's Trump and the White House. And not only do you not have agreement between Trump and the GOP in the Senate, you also have some divisions amongst the GOP in the Senate, and they are far apart from where the Democrats in the House and the Senate are. And these are mostly related to issues completely unrelated to immigration. Things like whether or not the $600 extended unemployment benefit should be continued, whether or not there should be bailouts for cities and states that are finding really difficult to manage the budget crunch that COVID is causing them. President Trump has indicated that he really wants to see a payroll tax holiday, which would, or at least defer payment of Social Security, Medicare taxes by those who are still working. Senate Republicans are not really thrilled with that idea at all, but the president is insisting. And as of late, the president has talked about trying to do some of this by executive order. All of which is to say, those are fundamental pieces of whatever the latest CARES Act support bill is going to include. Immigration is tangential. And so what tends to happen in these big negotiations is once they come to agreement, some sort of agreement on those big picture things, then they will look to see what other things they think they can include to grow the vote, or at least to make sure that the bill can pass with the minimum majority needed. The immigration bills will be part of that secondary discussion, but I don't think you're going to see a lot of people working on it until they have some idea of where the leadership is going to be on those big issues. That having been said, having Republican champions on these issues in the Senate is helpful. There are, of course, going to be Republican opponents of these measures. And a lot depends on the leverage the Democrats bring to bear. The bill has to pass the Democratic majority House as well as the Republican majority Senate. If McConnell can't rely on all of his Republican members to support it, they're going to need Democratic votes. They still have a 60-vote requirement to get over a filibuster. And of course, the president has to decide what he's going to sign. All of which is to say this is a real high tension wire act. It shifts hourly, if not daily. The Senate has decided it's going to not go on vacation next week as they had proposed to do to try to come to some agreement. And we'll hold our breath and wait and see.
All right, that's a good place to leave it for today. Theresa, Cris, thanks for joining me. And thanks to you for listening. We'll be back in 2 weeks. Before we go, a quick reminder to subscribe, rate, and review this podcast on Apple Podcasts, Google Play, Stitcher, Spotify, or your favorite platform. You can also find more information on all the issues we discuss here on the show at bipartisanpolicy.org/immigration. This Week in Immigration was created by Theresa Cardinal Brown and myself. The executive producer of This Week in Immigration is Theresa Cardinal Brown. This week's episode was written by Cris Ramón and myself. Our producers are Cris Ramón and Yafet Tawahara, and our editor is Yafet Tawahara. The executive producer of BPC Podcasts is Ashley Swearingen. I'm Jordan LaPier. Join us again next time on This Week in Immigration.